My name is Layne Stover, and today we're going to be talking about the data protection conflicts between the US and EU in the war on terror. In 2006, there were two significant issues that arose. On our slides here, the European Court of Justice, the ECJ, annulled agreement between US and European Union in regards to airline passenger transfer information, also known as the PNR. We'll get into that in a minute. In 2006, the New York Times revealed a secret U.S. surveillance program called Terrorist Finance Tracking Program, the TFTP. Common ground on the two countries are as follows. The two countries must find common ground in relation to their data protection policies on these two distinct problems. For this to happen, the article by Van Washenova, he's an article I use for most of this presentation, recommends the U.S. do two things. First, terminate the TFTP and improve the current system of financial information exchange. And second, apply the current system of financial information in exchange to the PNR data transfer process. The PNR is what the European countries tend to use more than the tracking program for terrorists the U.S. uses. So we use an article by Christina Popp here, and that is called the EU versus US, what are the differences between their data privacy laws? The GDPR, General Data Protection Regulation, is a comprehensive data privacy law that applies to organizations that collect, store, or hold personal data belongings to data subjects in EU member states. The European Commission defines personal data as any information that relates to an individual. This is implemented in May of 2018. It became the new legal precedent of data collection and privacy for the European Union. So the European Union uses the GDPR and holds its citizens' personal data a lot more precedent than the United States does. The United States will prioritize big business data instead of the individual's data, while the EU is completely flip-flopped. They prioritize the citizens' data over the big business data. That's on this side, we talk about the differences in those two. So the U.S. data protection laws overview. U.S. data privacy laws are fragmented depending on the type of data. So there's three main ones. For healthcare and information protected through HIPAA, which is, we all know HIPAA through your doctors can't give out your information freely. Financial institution security concerns information is protected by the GLBA. The federal agency's IT systems management is protected through FISMA. So those three mains is what keeps all of our data safe in the United States. The U.S. Privacy Acts focus on commerce, which are often let security trump individual privacy, like I was talking about earlier. So your individual privacy will get trumped by security and bigger businesses wanting to use your data. It all kind of comes down to money. This graph shows the number of data breaches in the millions. The US has quite a few more data breaches than EU. So the differences here on this slide is EU desires to restrict the amount of data collected and stop the data from being used for purposes other than the reason it was collected. McCoy, another article I used for this slide, speaks of this approach as the top-down, making it a clear priority. So the EU uses a top-down, so from the individual down to the big business and governments, and they don't want to use the information for anything other than it was originally collected for, unlike the United States. The US allows the broader data collection and storage as not high and tight in the protection policies and only legislates restrictions when individual problems arise. McCoy speaks of this approach as the bottom-up approach that the US is still searching for a solution to. So the bottom-up approach is big business up to the individual. So your individual can easily be trumped. Your privacy laws are a little bit more flexible on how the US can use your individual privacy instead of an EU, how they're very strict on how they use it. And they don't want to use it for anything more. But the US will use yours and give out information a lot more freely, not free, but a lot more freely than the Europe Union will do. They're still looking for a solution on this to help the individual's privacy even more. So now we're going to get into the facts of the PNR transfers. So 2 months after 9/11 terrorist attack, the U.S. authorized the Aviation and Transportation Security Act of 2001. That's called the ATSA. The required all airlines to provide access to passenger name records, the PNR, to use U.S. Customs and other federal agencies for the purpose of national security, as the ATSA forced European airlines to violate their data protection directive or pay large penalties. Transatlantic conflict over data privacy began. This is the biggest conflict the two had. So the European Union had the PNR set up, but after the 9/11 terrorist attacks, U.S. decided that they weren't going to quite abide by the PNR and they needed more security, so they went into their next act. They met in 2003 to negotiate a solution. The U.S. agreed to limit its PNR requests to a closed list, delete all categories of sensitive data, and only use to combat terrorism and crime, and keep no longer than 3.5 years. So they decided to come back on how much data they collect through the PNR, so they weren't as against the European laws of the PNR. So in May of 2008-2004, the US and EU signed an agreement on the PNR data. So they kind of revised it so they could kind of come to some common ground here and get to where they need to be. So on July 27, 2004, annulment of the signed agreement was filed. The European Parliament argued that the European Union does not constitute an appropriate legal basis for the Council and gave them until September 30th, 2006 to work out a new agreement. A new agreement was reached on October 1st, 2006. So this sit down was completely used to try and find common ground in between the US's approach to big business down to the individual and EU's starting an individual down to big business and government. Because the EU did not want to save all of their citizens' records under the PNR, because that's why it was implemented in the first place, to try to keep their personal privacy safe. The United States was using their personal privacy when they shouldn't have and against EU's laws. So they sat down here to annul the PNR and come to a common ground. And like on the last slide we were talking about earlier, they delete all sensitive information and only collect it for 3.5 years. So the US is really only trying to use this data for crime and terrorist organizations to track passengers and money as well. But the EU obviously, as stated, had a big problem with this. So that's why this sit down occurred. So the facts of the TFTP, which was the US's kind of return to safety here. In June of 2006, the New York Times reported on the Terrorist Financing Tracking Program, the TFTP. It is run by the CIA and is overseen by the Treasury Department. It acquires information from the world's largest financial network, the Society for Worldwide Interbank Financial Telecommunication, SWIFT. I said that a little fast. The Society for Worldwide Interbank Financial Telecommunication. Since 9/11 terrorist attacks, the US had secretly requested financial information from SWIFT. SWIFT is a Belgian company that is used by 200 countries and more than 8,100 financial institutes. As soon as New York Times released details of the TFTP, EU had concerns if the program violated their privacy laws. So when the United States came out with this, once again, just like EU was concerned about the PNR agreement, the US could have been violating their PNR agreement and their laws using the TFTP. So another sit down will have to occur. So in November 22nd of 2006, EU issued an opinion stating that SWIFT violated the directive and calls for it to cease all infringements. They shifted to focus on aiding SWIFT in complying with the data protection directive and make sure their clients know that the US authorities may have access to the client's personal data. So EU was just kind of letting their citizens know what was going on and that it was violating their agreements. In June 28, 2007, SWIFT joined the safe harbor, and the representation provided assurance that the US will be following the EU data protection principles. So SWIFT stepped up, joined the US, and then told the EU pretty much, hey, we're going to switch up the way we do things and comply to y'all's rules and laws. That is about it for my presentation here. After they made that revision to the TFTP, That's the same thing we have up until today, but as data acquisition grows and bigger data fields have come into play, bigger databases, they're probably going to have to sit down and revisit the TFTP and the PNR in the future, because as more companies need data, as more crime rises, as more terrorism rises, they're going to have to go down and sit down and find common ground again, like they did in 2007 and again in 2006 in the PNR. But we're excited to hear. These are the 4 articles I used mostly throughout my presentation and slides. And that's about it. Thank you.